Thank you for those joining us today for ILTA's webinar on the new disclosure financial interest form. Hopefully it is of use to you. It's meant to be kind of a preliminary introduction to this new form or the changes to the form for 2022. Lee Curry, an ILTA board member and co-chair of Legislative Committee, will be walking us through that. Given the shortness and efficiency, we're going to try to walk through this this morning. I will, without further ado, turn it over to Lee and say thank you to him for doing this for us.
Great, thanks, Brian. So this morning we're just going to go over the form, a little background, a little basis for it in the Title Act, and really just try to give you the information that the form is out there, what it looks like, and what the new instructions look like, and the effective date. And then once we get into probably the new year 2022, we'll probably do some more in-depth things. Plus, your companies, your underwriters, they're going to be delving into this and giving direction too. So without further ado, so the Illinois Title Act, section 215 ILCS 155/18 sub B, just as background, that's the section of the Title Act that provides for a disclosure form, provides that a producer of title business or any associate that has a financial interest in the title company has to disclose that to the party paying for products or services. And that's why the disclosure form exists, because of this section in the Title Act. This is the old form that we've had for many years. And you can see at the top, it has an effective date of May 1st of 97. So that's the form that was in place and has been in place and in use since 97. It has the seller's and owner's information, property address at the top, the title company's name, and then the title policy fee, mortgage title policy fee, escrow or closing fee, has a line for other fees, estimated total charges, signature line for the producer, and then an acknowledgement signature line as well for the buyer and seller. So just going over a brief timeline for what we've been involved with since 2018. Just in case you may have forgotten, April 3rd, 2018, the IDFPR announces that there's going to be a new DS1 form, and it's going to be effective the very next day. Obviously, that is problematic. Hard for us to implement a form with less than a day notice. The ILTA communicated concerns to the department on May 15th, or communicated the concerns, and that effective date was moved back to May 15 to try to give us a little more time to have those discussions with the IDFPR. On April 27th, the ILTA Board of Directors did meet with Deputy Director of the department at that time, John Lartz, to voice our concerns, voice problems that we had with the new form. And then based on some of the conversations with ILTA and the Board of Directors, the department extended the effective date to June 1 on that form that they had put out. We had continued those conversations with the department, ILTA did, and other industry members. And then on May 23rd, the department extended the effective date again to July 1st of 2018. The ILTA put together a working group consisting of three people, plus the executive director of ILTA at the time, and also an attorney that ILTA had retained just in case we weren't able to work out something with the IDFPR and then ended up having to file a lawsuit. That meeting was on May 30th. It was about 2 hours long, tried to make some points about what we were concerned with the form, parts where they were overreaching, parts of the form that didn't follow the act. And then based on that meeting, there were some various forms that were introduced or changes that were made to the form. But not quite enough to get us there. Then June 26th, there was a meeting with the IDFPR hosted by ATG, IRILA, CBA, and ILTA also attended. After that meeting, the IDFPR did not extend that July 1st effective date again. And then the TRO lawsuit was filed on June 29th, 2018, and ILTA joined that lawsuit along with a couple. There was a filed by ATG and PNTN, and then ILTA, or the PNTN was joined later. So that litigation has been going on since 2018. As of a few weeks ago, there was a settlement reached as to what the form could look like, where the parties were agreeing what the new form would be. The order dismissing the case has been sent to the court, but as of yet not entered. We're still waiting for that order to be entered. So the case officially isn't settled, but all the parties have agreed to it. There's a link on this. Brian sent out the PDF, so you can link to the forms on the IDF is that on our website. So, and this is what the new form looks like. Starts off with the disclosure of interest. We're going to go through each of these sections real briefly, just to give you a closer up look at what those are. So the new form has 6 sections: a transaction information section, an important consumer information section, estimated seller, buyer, and title and escrow charges, a premium split percentage or same payment amount section, a certification of disclosure, and an acknowledgement section. So the first section is the transaction information section. Starts off with property address, buyer and borrower's name, seller's name, title agent name, address, registration number, escrow service provider name and license number, and title insurance company name and license number. Title insurance company being the underwriter. Important consumer information. These are the bullet points that the IDFPR was very keen on having included. The first one, party paying for any title insurance policy has the right to choose their title agent. That repeats the section of the Title Act that gives the party paying the right to choose their provider. The next bullet point, when there's a financial interest between the person or company referring you for title insurance and the entity to whom you're referred, that relationship must be disclosed to you. That's what this form is for. They wanted the next bullet point in there, considering shopping around for title insurance related services to make sure you get the best value. Being a knowledgeable consumer can potentially save you money at closing, exclamation point. State law requires that this disclosure be provided to you before the commitment is issued. So that's an important thing to remember, that the Act does require that the disclosure form go out prior to the commitment being issued. And that bullet point repeats that requirement under the Act. And then state and federal laws help protect consumers by making them aware of the cost of title insurance and closing fees before those items are purchased. The next section is the title and escrow charges. There is called estimated because obviously these charges are going out prior to the commitment, and so that'll be sometime before the closing actually happens. So those things could change. The first one, owner's title policy, title insurance policy premium. Loan title insurance policy premium is the next one. Abstracting, searching, and examining fees, if those are charged separately. Preliminary report, a commitment fee, if there's an et cetera, if that's charged. And then a closing, escrow, and settlement fee, et cetera, is the next line. And then a total of those charges. And that's those are the charges that are listed in here. This box does not include endorsements, since sometimes those are not available prior to the commitment being issued. Not sure what the insurers are going to request, so that the endorsements are not included in this section. The premium slip, this part is new and something that the department was adamant about having. Please note the name of the producer is estimated to receive a percentage split of the premium or the actual dollar amount of the owner's premium, and the name of the producer is also estimated to receive a percentage or the actual amount of the loan title policy premium. You'll see that the word or is in there, so it's either or. Obviously, a producer could put both in there if they wanted, but it requires one or the other, the percentage premium split or the actual amount of the cost, or the actual amount of the premium going to the agent or the producer. So and again, this is estimated because it's going out prior to the commitment being issued. The next section is the certificate of disclosure. This section requires the producer to identify if they're also the title agent, that there's a box there they have to check. And then it also is that producer making an affirmative statement that they sent out the disclosure to the buyer and seller prior to the issuance of the commitment. So the producer stating that they've complied with the statute. And that section is new. The acknowledgement section is here. There was an acknowledgement section on the original form, and there's an acknowledgement section on this form as well. We have read the disclosure of financial interest and understand that the name of the producer is referring or has referred me/us to purchase title services from the title insurance service provider noted above, and will receive money or other benefit for the work provided, which is a direct result of the referral, and then a place for the sellers and the buyers to sign and date. So that is a quick run through of the new form. Obviously, as we said, we're just trying to get this information out to you, and then once we get into the new year, we'll be able to delve into these forms a little more. And then obviously your companies and your underwriters are going to be providing some guidance on those as well. Along with the new form are the new DS1 instructions. There's a link on that page to go to the form. So I did not include a copy of that because it was multiple pages. So instead of having 3 pages, of the form, we're just going to go through the sections. So the instructions, the instructions don't go to the consumer. These are to the producer and or agent to give them instructions on how to complete the form. So the first form, and this form is required under the Title Insurance Act, has been updated to inform the parties purchasing title insurance products and services, sellers and buyers, i.e. sellers and buyers, that the parties paying for any title insurance policy have the right to choose their title insurance agent, company and escrow, closing service provider, and list the sites for that, both state and federal. Other consumer protection information provided to consumers. The producer of the title business or associates have disclosed the title insurers, title agents, and independent escrow to whom they have referred the sellers and buyers. So they're again referring back to the Title Act. That's subsection 18B, 155 18B, that requires that a disclosure be made if a producer has a financial interest. And then it also lists the estimated cost of the title insurance. So here really the instructions are just explaining how to complete the form. So continuing, they break down some of the same sections, general information, about the form, except for the signatures and the sellers and buyers. The form is going to be a fillable PDF by clicking on the blank, similar to the form that already exists. Repeats going through the sections that we identified in our previous slides. The transaction information gives direction as to completing that. Fill in the property address that is subject to the transaction, the date the disclosure be made, the names and the addresses of the sellers, buyers, title agent, title insurer, and or independent escrowee to which the party is being referred. All of that information is that transaction information at the top. The certification of disclosure, they go to the bottom, to the next to last section of the progression of the form in this next part of the instructions, talking about the portion that's not fillable. That's a signature section, so it has to be signed by the producer and or associate with the appropriate date. The purpose of the form is to provide consumer information, information for the sellers and the buyers. So those bullet points that the department wanted at the beginning, nothing to fill in then, those bullet points will be standard across every form. They'll be included in every form. So the estimate of title charges and disclosure of the associated business interest. So you're filling in, the estimate of title charges on the DS1 form. We're filling in the estimated charges for the seller and the buyer. Breakdown is derived from the Act, that's subsection 19, where it references those. So those same sections that appear on the form are referenced in the Act. Fill in the name of the producer and associate above and below, and fill in the dollar amounts or the percentages. Here they're going to that section where we talked about that we split out on the prior section, or the prior part of the slideshow, to show where the producer and associate is getting the percentage, identifying that percentage and or that amount. So that's the next part of the instructions, telling you to fill in the dollar amounts or percentages of those lenders' policies and owners' policies that are going, of the premium that are going to the producer and associate. There's a note, please note the Real Estate and Settlement Procedures Act. This is not on the DS1 form, but a note in the instructions, just to remind the producer and or agent that the Real Estate and Settlement Procedures Act provides that no person shall give and no person shall accept any portion, split, or percentage of any charge made or received for the rendering of real estate settlement service in connection with a transaction involving a federally related mortgage loan other than for services actually performed. And then there's the section 8B from RESPA, where that provision is taken from. So the next section of the DS form, these instructions, the producer associate must check the box if they're also acting as the title agent. That's in that section that we talked about. So the signature of the representative of the producer and associate required, although the department did state in this section that it can be completed digitally using that form to indicate that it's a digital signature. So it'll be interesting to see how that is played out going forward. The signed disclosure shall be forwarded to the parties prior to issuance of the title commitment. Again, repeating that the DS1 form by statute is required to go out prior to the commitment. Please note the disclosure shall be sent electronically or by U.S. mail or by personal delivery by the producer associate to the seller or buyer. So it can be emailed, it can be U.S. mailed, or hand delivered if the producer is having to meet in person. In situations where the owner's policy and lender's policy are recommended by separate producers or associates, 2 disclosures are required. If you have a bifurcated deal, then both sides have to have a disclosure form issued prior to that commitment going out. And then also another please note from the department, the Illinois Department of Financial and Professional Regulation has regulatory authority over the title industry, and the authority is derived from the Title Insurance Act administrative rules and through RESPA. So the acknowledgement section, disclosures to be signed by the seller and buyer. You'll note that it says in the instructions should be returned to the producer associate. And that was a point of contention. The producer or associate of the producer has no control over the seller or buyer to make sure that form comes back. So the department wanted it to be mandatory, but the parties in the industry and ILTA pushed for it to be should. So while it would be nice if the seller and buyer got that back to you so you have proof that it was delivered by those signatures, it is not required under the form, but it is recommended. So the producer associate shall send the disclosure, again, just to repeat, by electronic mail, personal delivery, or first class mail, or person. And then the producer associate, an important part here, retain a copy of the electronic mail or letter sent by personal delivery or U.S. mail for a period of 3 years to confirm the disclosures were sent. So not only does that disclosure have to go out, but that form, a copy of the form and a copy of the email, a copy of the letter that was sent by the producer or associate has to be retained for 3 years. The DS1 record keeping, part of the instructions. So in this section, the department is, the first part of it, the act requires the disclosure be provided to the parties paying for title insurance prior to the issuance of the title commitment, and that it be maintained by the title insurer, agent, or independent escrow for 3 years. And then also that refers back to that subsection 18B. So 18B provides for the requirement for the disclosure and also provides for that 3-year retention, but it uses the keyword or, so it has to be one of those parties. Insurer, agent, independent escrow for 3 years. The next section the department wanted in the instructions, the department recommends that all capital ALL title entities involved in the transaction, meaning the producer associate, the producer, the insurer, the agent agency, independent escrowee, and settlement service provider maintain access to the signed DS1 in the records for their records to ensure that entities are properly authorized to complete the transaction. The department recommends it. It is not required by the DS1 form, but it's recommended, also not required by the statute, but the department again recommending that all parties either have the form or have access to the form, and then that form does have to be kept for 3 years under the statute. The last part of the instructions, any questions under the form can be submitted to the dfi.title@illinois.gov. So that is a quick run through of the DS1 form and the instructions that are going to accompany it. Like we said, those forms were part of the settlement of the case not settled yet. The implementation date for those forms as it stands now is March 1st of 2022. So that, to be implemented not later than that date. So that's the date when everybody should be shooting for to have that new form in your system and available to be sent out to the buyer, seller, borrower. And that is our quick fact presentation on the new form. Like I said, we wanted to get that information out since that settlement was relatively recently reached just a few weeks ago. Like I said, we're still waiting for that form that order to be entered in the court to make that case be officially dismissed and over. But we wanted to get this information out to you so that you can start making plans to get that form entered in your system, and also start working with your companies and your underwriters to be ready to go.
Thank you, Lee. And with that, we will open it up to whether you want to type in the Q&A question and answer section or chat any questions you may have. We will also send out a survey for any aspects. As Lee mentioned, we will certainly as an association try to do deeper dives where members and industry practitioners do have more issues or more follow-up they want to dig into more, potentially through webinars. For now, if you do have any questions, one that did come in, Lee, just ask to reemphasize, as you had mentioned, producers and associates being impacted, the who is impacted. I was going to maybe read briefly the statutory sections and thought maybe you could more efficiently just kind of then highlight after I read that the those impacted when referring to producers, associates, and the statute sections, as in the definition section 3 of the Act for anyone, referencing subsections 4 and subsection 5 of section 3 of the Title Insurance Act for reference today. And then the recording, producer of title insurance is any person or other legal entity engaged in the state and trade, business, occupation, or profession of 1, buying or selling interest in real property, 2, making loans secured by interests in real property, or 3, acting as broker, agent, attorney, or representative of natural persons or other legal entities that buy or sell interest in real property, or that lend money with such interest as security. That's subsection 4 of the definitions for producer. And associate is any firm, association, partnership, corporation, or other legal entity organized for profit in which a producer of title insurance, a title business, is a director, officer, or partner, or owner of a financial interest in such entity. Any legal entity that controls, is controlled by, or is under common control with a producer of title and title business. Any natural person or legal entity with whom a producer of title business has any agreement, arrangement, or understanding, or pursues any course of conduct that the purpose of which is to evade the provisions of this act. So the associate definition under subsection 5 is a lot more fun. And the drafting staff had obviously fun writing that. But Lee, if you wanted to just kind of remind everyone the gist of those that may have interest in this or want to share with their colleagues that they want to pay attention to this form, I think that would be helpful too.
Well, so generally, if you've got, and obviously that last part of the producer definition is going to be pretty key to a bulk of our agents, realtors, attorney agents, and those are the key producers that we're going to see most of, right? If you have a realtor that also has a title company, if you have an attorney that's a title agent, that's certainly going to fall in the definition of producer, and that's going to be the bulk of it. Title agent, obviously. Well, title agent, if we're talking about more of a full service agent or an escrow company, may not follow on that, depending on whether or not they're bringing in that business, referring that business. So that's going to be something that you have to look at the transaction specific. But generally, just generally, certainly an attorney that's acting as title agent could qualify as a producer under the statute.
Thank you, Lee. We'll give maybe another few seconds if there are any other questions and answers. Otherwise, thank you for everyone's time. This will be getting posted and shared for any of your colleagues that were unable to make today's webinar, and we'll be following up with any questions for deeper dives going into 2022 prior to the March 1st implementation date. And with that, I do not see any others. Lee, thank you again, and thank you for those that are joining it. I hope everyone has a happy holiday.
Thanks.